5 things to not put in your will. Hey, estate planning attorney Jason Gray here with Pinnacle Estate Planning, and in this video we're going to talk about 5 things that you should not put in your will. In many cases here in Washington state, people try to create DIY wills or use online services that don't account for our specific requirements. And sometimes these DIY wills, we see people just dump everything they're thinking onto the paper. They're writing and they're writing all kinds of stuff that really shouldn't be in the will. So I'm going to walk you through 5 things that really shouldn't be in your will. Number 1 is funeral arrangements. You know, it's probably not a good idea to pass away. Your family buries you 6 feet underground, and then a week later they open up your will and discover that you wanted to be cremated. You know, then the family has a decision to make. What do we do? So there's a right way and a wrong way to document your funeral wishes, whether it's informally communicating to family members or creating a separate document that specifies who has the right to make those decisions, but putting it in the will, because the will often isn't reviewed until sometimes weeks after someone passes away. That's not the place to do it. Here in Washington, we have what's called a disposition authorization form, which specifically addresses your funeral wishes, and unlike a will, this can be immediately accessed when needed. Number 2, designating who gets your IRA or your individual retirement account. We see this not only in those DIY wills where people don't know any better, but sometimes we see this in wills drafted by attorneys where there's a provision that says, and for many families, their IRA is their single largest financial asset. Some people have a home in Seattle or Spokane that's worth $500,000, and they have a checking account with $10,000 in it, and they have an IRA worth $1 million because they built it up over so many years working for companies like Microsoft, Amazon, Boeing, having a 401k. They retired, rolled that over into an IRA. That's by far their largest asset. And in their will, they mistakenly put, I leave my IRA to Fred, but 25 years earlier when they set up the IRA account, they designated Darla as the beneficiary on the beneficiary designation form. They don't remember doing this because it was 25 years ago, but when they set up the account, they had to designate a beneficiary and they chose Darla. Well, they pass away. Who gets the money? Darla gets the money because she was the designated beneficiary. What it states in the will about where the IRA goes means nothing. Now, there is kind of an exception here if on the IRA beneficiary designation form, it designates the estate as the beneficiary, which it never should. There's no reason to do that, and there can be negative tax consequences for doing that. Then it would flow through to the estate and goes to the heirs named in the will, but that's the only time where the will may impact where an IRA might go. Make sure you designate beneficiaries properly on those IRA accounts. Number 3, your life support machine decisions. So many people come in and tell me, look, if there's no hope, if I'm a vegetable and I'm just hooked up to machines, I don't want to see my family suffer. I don't want to incur a lot of expense. If there's no chance that I can come out of this and have any quality of life, let me go, take me off the machines. But again, putting that in a will is not the place to do that. In Washington, we use what's called a healthcare directive in conjunction with your durable power of attorney for healthcare. It's a separate document. When you're admitted to a hospital here, you're likely going to be asked, do you have an advanced directive? Maybe the word will shouldn't be in living will or advanced healthcare directive because too many people confuse their living will with their last will and testament, so they think it's the same thing. But your life support decisions should be documented in your healthcare directive, not your last will or your last will and testament. Number 4, assets in a trust. Now, many families have gone to attorneys and set up trusts or living trusts. They do that because they don't want their survivors, their family members, to have to go through the court and attorney involvement of probate when they die. So they put their assets in a trust. Let's say they put their home in Bellevue and their stock account in their trust, and then in their will they say, I want all my stock to go to Samantha, and then they pass away. And guess who doesn't get the stock? Samantha, because the trust instrument controls where the assets go. So the will only controls the assets that are in your name when you die. If you've moved assets into a trust, the trust really replaces the will for those assets, and the trust instrument determines who gets those trust assets when you die. So who gets the stock is based on the terms of the trust. Now, maybe in your trust, you said, when I die, I want my stock to go to Samantha, and then you put that in the appropriate way in the trust instrument, then Samantha would get it. But if the trust says, when I die, the trust assets go to my 3 children equally, that stock's going to the 3 children equally. So be conscious of the fact that your trust determines where the assets go, not your will. Number 5, similar to the IRAs that I discussed in number 2, number 5 is life insurance and annuities. You bought life insurance 40 years ago and you have absolutely no recollection that you designated beneficiaries when you acquired the life insurance policy. But now that insurance is worth $200,000, and in your will you say, I want my grandson Mark to get my $200,000 life insurance policy. Good job, Mark. But then 40 years ago or 30 years ago or 10 years ago when you acquired the life insurance policy, you designated Mary to get the life insurance. So she's the one listed as the designated beneficiary. I think most people know this, but Mary's going to get that life insurance because she's the one designated as the beneficiary on the life insurance beneficiary designation form, even though in your will you said you wanted another person to get your life insurance proceeds. Same thing applies with annuities. Annuities and life insurance, also by insurance companies, all have beneficiary designations, kind of like the IRA. There is this exception when the estate is designated as the beneficiary, then what's in the will does have an impact on where those life insurance proceeds, annuity proceeds, or IRA proceeds may go. All right, so that's a quickie on 5 different things that you shouldn't include in your will. Before I wrap up, I want to mention that at Pinnacle Estate Planning, we understand how confusing all of this can be. That's why we offer a free 30-minute consultation to help you understand your options and create a plan that truly works for you and your family. Washington State has specific laws about estate planning that differ from other states, and having a locally experienced attorney can make all the difference. Whether you own a home, have retirement accounts, or just want to make sure that your wishes are carried out, we're here to help create a plan that gives you peace of mind. Our clients consistently tell us they leave our office feeling relieved that they finally have their affairs in order. Estate planning isn't just about documents, it's about protecting the people you love and the legacy you've worked so hard to build. If you'd like to learn more about how we can help, just click the link in the description to schedule your free consultation. There's absolutely no obligation, and you might be surprised at how straightforward and affordable proper planning can be. Make sure you hit the like button if you found this helpful, and if you haven't already subscribed, hit the notification bell. That way you won't miss anything. I'm taking off for now in my office right now, off to a meeting. We'll see you next time. Take care.